Hi again out there in Freeman land. Over the last few weeks I've had quite a number of inquiries about people who have actually ended up in court and have sort of come unstuck in a big way. And so I thought I'd put this little presentation together to help some of you who haven't perhaps got as far along the path with doing the paperwork and are still at the courtroom stage. Because once you get the paperwork done, you will never need to go to court again. So this is for the people who have unfortunately ended up in the courts, and it is a scary place to be. But we never go there. Only corporations go to court. So the first thing you've got to learn to do is to make sure that the paperwork is correct, and you'll never need to go to court again. So but for those who haven't got there, let's have a look and see how we can put this right. If you've not done the paperwork and do end up in court, here is what you have to do. To get us into the court, someone has to lay a charge. Now, the charge may be running a red light. It could be any number of things, but someone has to lay the charge. So we'll go to Bovier's online law dictionary, which is the easiest for most of you out there in Freeman land to access. Just go into Google and type in Bovier's online law dictionary and it will bring it up. And then you can have a look at every word that they're presenting to you, because it's most important to know the words if you're going to rebut anything that they say. So let's have a look at what charge is. Contracts. Straight away they're telling us what it is. It's a contract. It's an obligation entered into by the owner of an estate. Okay, now here's the clue. Who owns the estate? Well, as the government set the estate up, the government is the owner of the estate. So an obligation entered into by the owner of an estate, which makes the estate responsible for its performance. Okay, there's only one way that they can make it perform, and that's to trick us into performing. So once we know who we are, this makes it a lot easier. If we know that we're not that estate, we can rebut all their presumptions. Okay, now the next part says, any obligation binding upon him who enters into it, which may be removed or taken away by a discharge. Okay, so they're telling us there that we can discharge the charge. The next part says that particular kind of commission which one undertakes to perform for another. Now what they're telling us here is that the person who lays the charge against us is going to get a commission if they can get us to perform. So why do you think they try so hard to get us to go into the court and perform? Because once we get fined, they get a commission on it. Okay, which one undertakes to perform for another? In keeping the custody of goods, in keeping the custody of his goods. So they are holding on to our title of the estate. Okay, and this is what is called the charge. They're coming in with a charge against our estate, and they're trying to get a commission on it. Here in New Zealand, they do it under Section 49 of the District Court Act, and it's in one of my other videos that you can have a look at as well. Okay, but let's look a bit further into Bovier's online law dictionary again, and it tells you wills, devises, an obligation which a testator imposes on his devisee. Okay, so who's the testator and who's the devisee? So the testator is them, and they're imposing on us, as if the testator give Peter Blackacre and direct that he shall pay to John during his life an annuity of $100, which shall be a charge on the said land. Now we are the land. If you go back through some of my older videos, you will see that we are the land. Or if a legacy be and directed to be paid out of the real property. So what they're trying to do is to raid our property by getting us to perform. So if we know these sort of things, then we can start to discover what the courts are. But now let's look at the Butterworth's New Zealand Law Dictionary, And you'll see it's also the same, an encumbrance on the land or on a fund. Okay, and number 4, a commission. Okay, so once again, they're telling us that they can get a commission if they can get us to perform. It's very, very simple. It's all about money. Now all we have to find out is who is laying the charge, who the charge is against, and how to discharge it without going through all the rigmarole of getting convictions and all that sort of hoo-ha and paying huge amounts of money. So now the prosecutor comes into the picture. He's the one who lays the charge against the estate of John Doe. Now we are a deceased estate, so we've put the tombstone in there to show you who it's laid against. When we were born, an estate was created, and the prosecution must somehow get us to pay the charges for the estate. So if he can do that, he's going to get a commission. And that's the whole idea of what the court is. Now the prosecutor lodges the charge with the court registrar. The court registrar has a look at the document, and if she thinks that she can make money from it, she's going to put it before the court. Because the prosecutor is hoping that we don't know who we are, and is allaying a bet with the registrar that we do not know who we are. Therefore, if we don't know who we are, we're going to end up paying the charges out of our wallet. Now, I don't think many of us want to do that really, but however, the registrar accepts the wager, stamps it with the stamp, lodges it in the court, and sends the paperwork, which is only a bill of exchange. She sends the paperwork to the real live man. There's the real live man. Now, the real live man gets served documents and sees his name. And because we think that that name is actually us, we think it's meant for us. It's not though, folks. It's not. Okay, now one of two things is now likely to take place. And the first one is that we will panic and hire a lawyer. Or we may go along to the court and represent ourselves. Most of the people in the free man movement go along and represent themselves. But both are wrong. So we need to see why both are wrong. And it's really quite simple, is because represent, if we're going to represent ourselves, we have to look at it. Represent is actually two words, represent. Now, if you present yourself, that means you present yourself in front of someone. But if you represent, what you're actually doing is representing yourself as the fiction or the deceased estate. And here we go to Bovier's, and it says representation of persons, a fiction of the law. Now, if that doesn't wake you up to what's going on, then nothing will, because it's not fact, it's fiction. In other words, a fantasy. A fiction of the law, the effect of which is to put the representative in the place, degree, or right of the person represented. Okay, so what they're trying to do is to put us in place of the person which is the deceased estate. So therefore, the moment that we do stand up and say we're going to represent ourselves, we have got, or the courts have got, joinder between ourselves and the fiction. Now, I can't get any clearer than that, a fiction of the law. Therefore, never hire a lawyer and never represent yourself. If the judge sees that you have no lawyer, his first question is always going to be, do you have a lawyer? And if you don't, he'll say, are you going to represent yourself? Now, a lot of the people in the free man movement have in the past gone in and says, yes, I'm going to represent myself. But no, you must reply, I will be myself. Now let's look at the courtroom, because it's a scary, scary place. And if you don't know what's going on in there, then it makes it a lot harder. So the first thing that we have to realize is the judge is there to oversee the proceedings, because there are other players in the court which we're going to introduce you to. The prosecutor, he comes in on behalf of the Crown. Now, no matter what you've been told, no matter what you think, the Crown is actually your surname. Now, he is coming in on behalf of your surname or the deceased estate, but he's going to try to get you to pay the charges, which we will see. Now, the registrar comes in with the account books. Now, the registrar is the one taking the gamble, and she has to make sure that she is going to get this through, because what happens when you first go into court is that if they get a plea from you, then they're going to put a 90-day bond out, or the registrar is going to put a 90-day bond out onto the bond market with the hope of getting a monetary return. Okay, so we've got three of them there: judge, prosecutor, and registrar. Well, boy, that seems a bit stacked against us, doesn't it? So where do we, the real live men, fit into this picture? Well, it's going to be a switch and bait. They're going to try and switch us. The prosecutor needs us to step in and take over the role he is occupying, because he's coming in as trustee of the deceased estate, but he does not want to keep that role, because if he does, he's going to have to get his checkbook out and pay himself, and I don't think he would like that. But should the man appear in court, whether he's with a lawyer, whether he's going to represent himself, no matter what, there is a maxim at law that states the presence of the body corrects the flaw in the name. Okay, so your name is only John. It's not John Doe. So Doe is the Crown, but to get joinder, just the mere turning up in court, the presence of the body corrects the flaw in the name. So that's why we never go to court. We can throw it out before it gets there. Okay, now that we're in court, it's plain to see that we were totally disadvantaged. Three of them against us. There's only one way to get out of the situation, folks. As the prosecutor has laid the charges, we must attack him and get the judge on our side. If we do that, we're going to win. But to ensure that we're successful, we need to know just a couple of things. Anytime the judge addresses us, he is offering us a contract. So don't worry too much about the name thing. Don't get into big arguments about the name, because the name isn't that important, I can assure you. What is important is to see what he is offering us. It is a contract. Now, the way that we respond to the judge is, with all due respect, Your Honour, are you offering us a contract? If so, may we please have full disclosure of that contract. Now, whenever he says anything to us, we must respond to that. Don't try and argue the name. I can tell you, you're not going to get far with that. It's much better to try to, you'll see in a minute what we're going to do. Some of the contracts he will offer us are, please take a seat, or please be seated. What is your name? How do you plead? Please be quiet while I'm speaking. Now, if he offers you any one of those contracts, it is really, really important that you ask him if he is offering you a contract. But do it politely. Do it with all due respect, Your Honour. And remember this, the judge only has 3 shots or 3 attempts to get you into contract, and then he has to either leave the court or come in, bring something else into the court. And we've had judges leave the court and then come back in and have another 3 shots. We've had the judges come in and say, arrest that man, and we've told them not to take another step forward, because they're only offering you a contract. And if you accept that contract, you will be in trouble. The judge will try many things to unsettle us, but if we stand our ground and ask for disclosure of the contract in a polite tone, then they must listen to us. When you've been to court a few times, it becomes easier, and we jump in before the judge speaks normally. If we can get in, as soon as we walk in there and the judge just looks at you, we just say to him, Your Honour, with all due respect, before we proceed any further, may I ask the prosecution a question? Okay, the prosecutor is the one who has brought the charge, so we've got to address him. Should the judge intervene, politely ask, with all due respect, Your Honour, is he not the one bringing the charges? Why are you denying me the chance to talk to the man who is charging me? All right, because the judge will try to come to their aid all the time. In one court case, I actually said I was there on behalf of the Crown, and the one who had come in on behalf of the Crown, his eyes went as wide as saucers. Anyway, once we have the right to ask, we should ask the following questions. The following questions should have the charges dismissed or discharged. Any of the following questions will cause major embarrassment to the prosecutor, and the judge will try to intervene again. Now, you must say, are you trying to deny me justice, Your Honour? Number one, this is the first question you could ask. There's 5 or 6 of them here. Would the prosecutor please identify the defendant? Now, as I've told you earlier in the presentation, the defendant is a deceased estate. Is there any way that the prosecutor can identify the defendant? Absolutely no. Now, the first time I did this in court, the prosecutor picked up a piece of paper that had my name on it and held it out towards me with his right hand and said, "That's him over there." But he was actually holding the piece of paper in his right hand. So if they should try that trick on you, just say, would the prosecutor please put his hand on the shoulder of the defendant? Now, if you've done your paperwork wrong, they may be able to identify you, but it's still a long straw. Mr. Prosecutor, you presume to know who I am. Who are you? Now, that one will really make them squirm, because they are coming in as the prosecutor, as the trustee, and they're trying to switch you into that role. Mr. Prosecutor, may I have full disclosure? They can never, ever give us full disclosure. And the reason that if they gave full disclosure, they would have to identify the defendant. They would have to identify what they're actually doing, what the charges are, and various other things that they cannot disclose. It's impossible. They cannot give you full disclosure. Mr. Prosecutor, please identify the injured party. Now, if you've been caught for running a red light or speeding, there is no injured party. They cannot identify the injured party. Mr. Prosecutor, are you acting as trustee for John Doe Estate? Ooh, that one's going to get them. They could be administrator. So you could ask them, are you acting as trustee or administrator for John Doe Estate and trying to make me the trustee and you the beneficiary? Because that's what they're trying to do. They want to become the beneficiary and make you pay the charges. Mr. Prosecutor, are you trying to gain entry by deception and fraud? Now, entry, I won't go into it in this video, but you need to look up entry. It is in one of my other videos, but entry is entry into our state by deception and fraud, and they certainly are. They most certainly are. There are many more questions that could be asked, but there will be no need. As if he fails to answer any one of them, just turn to the judge and say, Your Honour, with all due respect, we now ask that this matter be discharged. They may still try to test us, as that is their job, but they're just making sure that we do know who we are and that we do know their procedure. And also be very careful whenever they address us as you, because we're not you, and say, Your Honour, would you please identify who you is? Because it's not us. Okay, now finally, just be safe in the fact that we are upholding our inherent rights. We have no right to be in the court. They're just using us for one thing. The court is actually the bank. It is the money system, and that's all they're trying to do, is make money out of us to keep their stupid corporation going. So I hope this has been helpful, and after a couple of times of watching it, you may feel a bit more secure in going to court, or you may do the way that we do it, rebut all the presumptions and never go to court. Good luck on your journey. Well, here we go again with another little video that is designed to help you overcome some of the problems you're having with corporations that are attacking you or your so-called straw man or your trust account. This little video may help you to understand what they're doing and how to overcome the little tricks that they are pulling on us. So the little tricks you need to know when faced with confrontation. These two little tricks here you really need to understand. If you do not know your rights, then you've got none. Absolutely none at all. You must know what your rights are. Now, every presentment or confrontation is merely an offer to contract. And most people, when they get a letter in the mail or something from a debt collection agency, a bank, or they get a summons to appear in court, they're absolutely panicking when all it is just an offer to contract. So get those two things clear in your mind. If you know your rights, then you have rights. So learning your rights and how to get around these things will help us immensely. Now, as we've learned in previous presentations, there's quite a few, I've put up quite a few videos now, so I don't like to keep repeating myself all the time, so you'll have to go back if you haven't seen them, if this is the first video you've seen. But our name is a corporation, okay? Knowing that our name is a corporation is going to help us a lot, because corporations are dead entities and they need a living being to assume responsibility for the corporation. Otherwise, they cannot function. Just like the courts need us to step up and take liability for our corporation or our name. So they come to the man. And so now what we're going to do is reverse those roles, and we're going to show you what you do to them to make them become liable for their corporation. So when we deal with a corporation, we need someone to step up and take liability for that corporation. Just the same as the courts do to us, we need to do the same to them. So if some corporation sends us a demand or any other kind offer, we need to have the name of the person that sent us that demand. Now, they don't like doing that. They don't like giving us the name. Since we discovered this little secret, not too many corporations are keen on signing their offers to us even. And what a lot of them are doing now is on behalf of the manager. But we have found ways to get around that. And sometimes it just takes a phone call and going right to the top saying, well, no, not happy with that. We want the name of the person that we are going to be talking to. They're very, very reluctant to give it to us now. Because they know that this is how we're going to stop the corporations in their tracks. Once we have the name, and I'll show you now what we do. The first thing, all correspondence that we receive must be replied to within 3 days. Now, there are ways and means of getting around this. You can take a little bit longer if you say that you did not get the the mail until a particular date. But however, there are ways around it. But normally, everything must be responded to within 3 days. And the second major detail is it must be addressed to an individual in their private capacity. We'll show you how to do that shortly. But it must be addressed to a living person in their private capacity. Our response must be sent via registered mail. The registered mail must be sent to a street address and to a named person. Okay, this is part of the registered mail terms and conditions, is that you must send it to a street address. They will not accept a PO box, and they will not accept it unless it is to a named person. So this is why a lot of companies will only give you PO boxes, and you will have a great deal of difficulty getting a street address out of them, but there are ways and means to do that. Okay, now thanks Brian for this registered post. This is what a registered post envelope looks like here in New Zealand. Now, the reason that we use a registered post envelope, and they do cost a bit more, so some of you are trying to short circuit it by doing it by courier. But if you go onto the New Zealand Post website, or if you're watching this overseas, go onto your Post website and you'll come up with something like this. The terms, and go into the terms and conditions. I just did a Google search and this is what it came up. What can't be sent? There are 2 types of items that you need to know about: prohibited items and restricted items. So let's have a look at prohibited items. Now, I've just taken a few of them here. There's a whole heap of them, but this is what cannot be sent in normal courier or normal mail. All these things outlined in blue here must be sent by registered mail. It is the only way that they can be sent. So traveller's checks, deeds, negotiable instruments. Now, what we're going to be sending them is a negotiable instrument, including any bearer security, bill of exchange or uncross-checked, bonds or shares, credit or bank cards, cash, currency, bullion or vouchers. Okay, so those things are the ones we're looking at. It does include fragile items, jewelry, collectible antiques, blah, blah, blah. But the most important thing that we are looking at is what we will be sending is a negotiable instrument. So that is what you ask for, a registered post envelope, and they do cost a little bit more, but hey, you've seen why. Now, all mail sent to a PO box and to a corporation will be ignored. They do not need to respond to us. And that's why we're not getting replies. And people saying, well, I wrote to them and they haven't responded. Okay, so now you can see why. And these are the little tricks of the trade that they use to stop us in our tracks. Unless the correspondence is directed to the real person that sent it to you, it will be ignored totally. Okay, so a corporation will ignore it, and unless it's sent to a named individual, it will be ignored. Right, now here's a letter. Now I've done it in 2 parts here because there's been a few complaints that the letters that I've written up are too small. They couldn't read them. So with a bit of luck, everyone, including someone with bad eyesight like me, will be able to read this. Now, the first thing you'll notice at the top there is that we have private. So we've received something. In this case, I'm doing it to a bank. So we're going to go back in private. And we're going to use our given names, which is John Henry. We're not going to be using Doe, because John Henry is the person's personal representative. And there's our street town. Now, we are going to address this to the person in his private capacity. So Bent Copper in his private capacity, 1 Rip-Off Lane, Skanksville. Now, we address it to him. Bent Copper in his private capacity. Now, here's something that you need to know what this here means. So let's have a look. The Court of Appeal has ruled that the use of without prejudice in communications is intended to encourage and facilitate the negotiation and settlement of disputes. Its use can help ensure that parties can make concessions and or admissions to try to reach a settlement, knowing that if settlement is unsuccessful, then those concessions, admissions will not be brought up in court and used against them. Oh! Very powerful, isn't it? It cannot be brought up in court and used against us. So in other words, what the court is stressing is that the need to ensure that parties to a dispute can freely and voluntarily undertake negotiations to try and settle a dispute in the knowledge that any acknowledgement or admission will not be used in any hearing, that's if negotiations fail, against the party who made the admission or acknowledgement. That is very, very powerful, and that's why we include that on our letters. Okay, now here's how we address it. First of all, you must respond to the letter that you received and acknowledge the letter. So, we, the underwriters, thank you for your final demand for payment dated 21st of August 2013 and bearing a postmark dated 28th of August 2013, which we received today, the 29th of August. Now, you'll notice that the date there that they wrote in their letter was the 21st of August, but they didn't post it until the 28th. So they're trying to delay the sending of the letter, thinking that that we're not smart enough to know that the 3 days of grace that we mentioned earlier is going to be up by the time we get the letter, and so there's nothing we can do about it. So we're addressing that right from the start. This is just one of the little tricks that they use against you. Okay, we continue. We are not certain exactly what Bent Copper is demanding in Bent Copper's letter to us, as in the second paragraph, and here I have it highlighted, accordingly the bank demands payment from you of $2,165, as there is no sum certain written, and the bank is making a demand on you. Now, the bank must put the amount in writing, because that there used to be a unit of silver, that symbol. Now it isn't. It's a nothing symbol. Okay? So it must be in writing, and it must be $2,165.25. That there is not a dollar sign. A dollar, as you've heard in previous videos, is a silver coin. Okay, then we go on to the notice, because we must notice them now. Okay, the notice. Bent Copper is hereby noticed that we will at all times promise to pay any alleged outstanding amount upon Bent Copper under his own full commercial capacity with clean hands and equity, providing full, complete, certain, and not misleading disclosure to the following questions. Now, they cannot do that with clean hands and equity, because they know that they are perpetrating fraud upon us, and so they cannot do it with clean hands and equity. Therefore, the questions, and you don't need 200 questions like some of them are putting out there in their letters. These 5, there is no way that they can answer any one of them. And the first one, that John Henry is you. Now, if you go back to the previous slide, they're demanding it that you make payment. Well, is John Henry you? He most certainly isn't. 2, that a sum certain has been demanded for payment by the bank. As I showed you, there is no sum certain. There's only a squiggly, there's an S with a line through it and then some numbers. So there's no written amount or sum certain. That anyone is able to make payment. we haven't been able to make payments since 1933. So no one can make payment. We can only promise to pay on demand. That's why we say up here, we at all times promise to pay any alleged outstanding amount. That way, they cannot default us. We're still promising to pay. Okay, number 4, that the bank gave full, complete, certain, and not misleading disclosure when loan number 123456 was approved, that we would need to sign a mortgage agreement before the loan would be credited to our account. Okay, once again, they're perpetrating fraud there. Now, the 5th one, what a lot of people don't realize is that that the security that the banks hold is not the house that you live in. Okay, so number 5 there, that the property secured by mortgage number 901-203-ABC is the house situated at 100 Short Street. Send a photo in. Okay, they know that that is not the security that they are threatening to sell. Okay, Bent Copper's failure within 14 days to provide full, complete, certain, and not misleading disclosure to all above questions will, in accordance satisfaction, see all alleged claims settled and closed. Now, here's another very powerful set of words here, and what we're trying to do is show you what these words mean so that you know. Accordance satisfaction, a method of discharging a claim whereby the parties agree to give and accept something in settlement of the claim and perform the agreement. The accord being the agreement and the satisfaction its execution or performance, and it is a new contract substituted for an old contract which is thereby discharged, or for an obligation, cause of action which is settled and must have all of the elements of a valid contract. Now, they know that they haven't given us a valid contract. It's a very one-sided contract that they have given us. So if you use that, they will be jumping and trying to nullify this very quickly, I can assure you. Now, we then put the private person's personal representative, and we sign that. Now we turn the letter over, and on the back at the bottom right hand corner of the letter we place a 5-cent stamp. Now, unfortunately, I couldn't find a New Zealand 5-cent stamp, so I've got an old Teddy Roosevelt United States postage stamp here. Now, this is what you must do. The day that you send the letter, you must stamp the date across like that. You must also put your name across like that. Now, the only reason I've put this in red is that you couldn't see it when it was in blue. So I've put this in red, John Henry. Okay, you must do that. Now, you see, what happens with a lot of documents is that they will turn the document over and it becomes an inchoate instrument. They will then fill it out because they have your signature on the front side, and they use your signature to create money. Okay, so the inchoate instrument on the back here could be filled out to raise more money for them. So by doing this, you have put a postage stamp on there. You are the last signature on that page. They cannot interfere with the post. By following their rules, we are now holding them accountable. So don't take shortcuts. Follow the procedures, and they must leave us alone. Good luck out there. Do it properly, do it right, and let's hold them accountable. Thank you.